So much, Katie Tour. We have a lot to get to tonight. We begin with this breaking news. Moments ago, a federal judge has ruled in the biggest case growing out of the Mueller report, ordering former White House counsel Don McGahn, the star witness of the Mueller report, to testify before Congress. As you probably know if you follow the news, this is a big decision that affects not only issues in the Mueller case, but the open impeachment probe, implications for many other White House officials and potential witnesses and Trump allies who have in various ways been delaying or refusing to testify in the impeachment probe into the alleged Ukraine bribery plot. We and our experts are poring over this decision, and given that it's breaking news, we're going to bring them right in. Former acting U.S. Solicitor General Neil Katyal, who's argued dozens of cases before the Supreme Court, including these kinds of interbranch issues. He also has a brand new book out, Impeach, the case against Donald Trump, coming out tomorrow. Harvard professor Leo Wright-Rigueur, and David Frum, a former speechwriter for George W. Bush, now at The Atlantic. Good evening to everyone. Neil, this is a decision many had been waiting on. We have not read all of it, but we have read some of it. Your view of the core news, the core holding here?
Yeah, so it's only come out 5 minutes ago, so I want to caution everyone. Everyone's got to study it. But boy, it looks like a complete win for Nancy Pelosi in the House of Representatives and a very devastating loss for the president. What the judge has done is the judge in D.C. has said that she's followed an earlier precedent by Judge Bates, a very respected judge appointed by Republican President Bush in D.C. to say that Harriet Miers had to testify. And similarly here, this judge has said now Don McGahn has to testify. That has massive implications because McGahn is all over some of the concerns about the cover-up that happened back with the Mueller investigation. So that's one thing, Ari. But the other, even more important thing, is that it's speculated that this may change the dynamics about whether or not former National Security Advisor John Bolton will now testify, and other folks. Remember, he had asked the court to say, hey, I'm not sure if I can testify or not. And it looks like this ruling's logic and reasoning is saying, oh, no, you got to testify. I mean, Trump made some absurd legal arguments saying that he was absolutely immune and his advisors couldn't testify. And this judge appears to have rejected all of that.
Yeah, Neil, you say all that, and as you mentioned, and I'll remind viewers as well, we are just getting, as we do on big Supreme Court days, we get a long ruling and we make sense of the high points. But I'm also, in the spirit of legal analysis and reporting, going to read some of what at the end looks like a very stark siding with the powers of Congress. Obviously, this Congress being run by Speaker Pelosi, as you say, to compel this kind of testimony. Reading from this, again, moments ago, just got the ruling. The judge saying, look, this echoes the Miers decision, as you mentioned, that was from a different era. The court adds, this is an inescapable conclusion because the subpoena is a legal construct, not a political one. And this is pretty significant, Neil, when you think about the debates we're having. It says, quote, no one is above the law.
Right. Yeah.
The reference there being to the potential civil defendant, Mr. McGahn, is not above the law. Do you read the reference that way?
I read it that way, but I read it more broadly. I mean, this opinion, just from the few minutes I've looked at it, is a rejoinder to the era of Trumpism, to the idea that absolute power means you, as a president, you can do whatever you want. And that was literally the president's argument in this case. He's absolutely immune from legal process. And I can't think of something more un-American, and Judge Jackson, following her predecessor, Judge Bates, appears to have reached the exact same conclusion.
And David Frum, who's obviously served in a White House, including the one that the Miers precedent reaches, no one in any courtroom or in any Congress would say that a subpoena means every single topic must be discussed. There are later protections for that. This was the more initial issue, or what lawyers would call the threshold issue, of whether this witness even comes before Congress in any valid way. And again, reading from a part of the opinion I haven't read yet, it says, when a duly authorized committee of Congress issues a valid subpoena to a current or former executive official, and a federal court determines that they, as a matter of law, have a duty to respond, the constitutional principles that animate the structure of our government are preserved. Your view, David, of the judge coming down in that way, that's saying this is bigger than what McGahn did, what he can and can't say. There are obviously some real privilege issues that would yet to be determined, but that it is in the interest of the U.S. constitutional order that Mr. McGahn and, as Neil said, potentially other people like Mr. Bolton ultimately face Congress.
Well, one of my longstanding worries about the Trump presidency was that President Trump's extreme claims in bad cases were going to take a lot of issues that had always been kind of blurry, exactly the limits of executive privilege. These questions have been blurry because they've tended not to be litigated, that the branches have mutually adjusted rather than refer to them to the court. And President Trump has made a series of outrageous, as Neil said, broad, crazy claims about presidential power. He's doing it obviously to cover up wrongdoing. And so the courts, how can they do anything otherwise than sharply limit presidential power? But someday we're going to need that presidential power for good ends. And I worry a lot that President Trump, by trying to corrupt the presidency, is going to end up leaving behind an institutionally weakened presidency against future Congresses with a lot of case law that says Congress can do more than we imagined 3 or 4 years ago that Congress could do.
Well, it's funny to hear you say that on a night like tonight when, again, for viewers just joining us, the White House getting a real stinging rebuke and loss in federal court, ordering Mueller star witness Don McGahn to testify before Congress, an issue live and in the heart of the impeachment probe. But, David, you're also partly echoing the concerns of another conservative former colleague of yours, Jack Goldsmith, who has argued, and he's known as a conservative, able legal mind, but he said what you've said, that basically if you die on too many hills and you fight tgoing many fights with bad arguments for executive power, you actually, he argues, Trump actually weakens the presidency.
Right. Well, we're going, one of the questions that has always been obscure in American history is what are the president's criminal liabilities in state law? The shoot the man on Fifth Avenue claim. And it's kind of blurry because weirdly, we've gotten through all these years of the Republic without litigating it because presidents have gotten through all these years of the Republic without committing any state crimes to litigate it. When you have a president who then commits a lot of state crimes, it raises a question. And probably we're going to end up with a Supreme Court ruling that, yes, the president is subject to state criminal process during his presidency. That's a bad outcome from my point of view, from a public policy point of view. It was better never to have tested it, to have left it blurry. But the way you don't test it is you don't commit crimes, and that seems too high a bar for this White House.
And Ari, if I could...
Well, you